Between 1798 and 1800, the United States and France were almost, but not quite, at war. There was no fighting on land and no fighting between their actual navies, but each side was paying privateers, essentially government-endorsed pirates, to sail around in the Caribbean and harass one another's shipping in order to interfere with trade. International law, as it stood at the time, however, said that neither country should interfere with the shipping of a neutral nation. In 1800, a merchant ship named the Jane sailed from Baltimore in the USA with a load of flour. The intention was to sell both the ship and the flour in the Swedish port of St. Bartholomew. Arriving there, they sold the flour, but then continued on to the Danish island of St. Thomas and sold the boat to a man named Jared Shattuck, who had been born in the USA but who was now a Danish citizen. He filled the boat with goods for trade, renamed it the Charming Betsey, and it set off for Guadeloupe, another island in the Caribbean. On the way there, the vessel was captured by French raiders, but just a couple of days later, it was boarded by American raiders, who kicked off the French and took the vessel to the British island of Martinique, where the cargo was sold and the vessel was forfeit. The owner sued in the American courts to have the vessel returned and claimed compensation because the vessel was owned by a citizen of a neutral country and therefore not open to attack. The difficulty was that the Act of Congress, which authorised the privateers to harass French shipping, didn't specifically exempt ships owned by citizens of neutral countries. The question for the court was whether it should nevertheless be read as though it included that limitation. The US Supreme Court said, "An act of Congress ought never to be construed to violate the law of nations, if any other possible construction remains, and consequently can never be construed to violate neutral rights or to affect neutral commerce further than is warranted by the law of nations as understood in this country." This principle, that where a statute can be read within international obligations, that meaning should be preferred to one which would contravene international obligations, is known in international law as the Charming Betsey principle.